Any mention?
Please, Your Lordship. Your Lordship, I beg to make a mention for item number 8. Lordship, I pray that this matter may come up after vacations, Your Lordship.
Who is the other side?
I am there, my lord. I have no objection.
No objection.
Highly obliged, Your Lordship.
Speak with the Learned Counsel for the petitioner. This is matter of clarification. Yes.
Your Lordship, I beg to mention item number 15 and 16. I'm appearing on behalf of the respondent 2, 3, and 4.
Yes.
Your Lordship, I pray that the matter may come up after vacations.
Speak by the Learned Counsel appearing for the respondent number so and so. This is matter of clarification. This will be 15 and 16.
Yes, but I beg to mention item number 12 of the hearing list. I have some difficulty today, Mulad. I have another matter in court number 2, slightly urgent. If your lordship will kindly accommodate me and fix it next week.
Next will be difficult, Mr. See, if we hear it also, there will be no time to pass.
Actually, they have shown some urgency. They've expressed some urgency in this matter.
My lord, the wife and child have not received anything till now. So, that is our urgency. I am dependent on my retired father. That is the only urgency, my lord.
This matter, I thought it should have pressed. See, like all along,
No,
there is no objection to the adjournment and all. Anyway, I do not know since it is maintenance.
My
matter, we
learned friend
have to-
also showed.
We also attempted to
seriousness
try and settle this
settle
matter.
matter,
We actually
but-
tried.
but it did not
what
work
they're
out,
asking
madam.
for is a little beyond his reach. That's the only difficulty.
It's a maintenance matter.
Yes, ma'am.
Maintenance.
We wanted to try and settle it once and for all.
And you are challenging it on what ground?
Look, we had filed an application for alteration of that maintenance amount because the court had passed an ex parte order without having the affidavit of assets and liabilities on
You are
record.
challenging the interim order here.
Yes, my lord. I'll show there are some Supreme Court decisions on this issue, my lord.
The scope is, I do not know, the interim order at what, why it could be interpreted at this stage? And you should, at least, is there any interim?
No, there is no stay from this court.
This
So why
there
you
is
are
no
not
stay.
paying then?
But the issue is beyond his reach. The court has passed an ex parte order which he's not in a position to pay. He has disclosed his assets. He does not even earn that much per month. His monthly salary does not meet it.
and
And just say respect for Mr. Shen, Learned Counsel for the petitioner. Release this matter after a week. We try, we'll give it a try, we'll just see.
Lordship.
my lord.
See, the 11th hour it becomes difficult and then urgent matters.
But
remain
I've also expressed to him that next week, after Friday, I will not be here. 12th is a holiday. 13th onwards, I'll not be here.
difficult. Let us
So
see. Let us
sometime
see
next week on the first 3 days. Monday,
We'll
Tuesday,
just
or
see.
Wednesday.
We'll just see. I mean, 12th also is a holiday.
Yes,
Yes,
so
my lord.
9,
If it
10th,
can come
11th.
on Monday also, we have no problem, my lord.
You do not have a problem. There are see, there are some
Provided
other
if your
matters.
lordship accommodates us, my lord.
See, this will remain. I will just see if it is possible. We'll take it up.
My lord. Oblige.
May it please your lordship, I beg to make a mention of item number 3.
Yes.
No objection.
Lordship, I pray this matter may be listed after vacations.
What is this matter about? None of you know.
My lord, I'm not the dealing counsel, my lord. Mr.
This is a difficult part. You see, nobody even bothers to read the files. Yes, suspect for by the learned counsel for the petitioner and not objected to by the learned counsel appearing for the respondents. This is matter appearing for the state respondents. You just record the name. Yes. This is matter after vacation.
Please, please your lordship, I beg to make a mention item number 6 and 7 is a connected matter. I humbly pray that this matter come after vacation, your lordship.
6 and 7, these are
Yes.
connected matters.
Yes,
My
sir.
lord. Connected. No objection.
No objection.
Same orders there also. Yes.
Hello, lordship.
Please, Your Lordship, I beg to mention item number 5. If this matter may
Yes.
kindly be taken up after vacation, Your Lordship. This is a criminal appeal here.
Yes, this was item 5, as straightforward with the learned counsel for the appellant. This is matter of yes.
Highly obliged.
Hello, obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 14. I pray the matter may be come up for vacation, Lordship.
Which the other side?
I'm the Lordship.
Yes, also same order. Yes.
Please, Your Lordship. Lordship, I beg to make a mention of item number 9, Your Lordship. I pray this matter may be listed after vacation, Your Lordship.
Lordship.
This was item 9, as it requested by the learned counsel for the petitioner, and this is matter of vacation. Yes. 9 and 10.
9, Your Lordship.
Only 9.
I'm for 1 to 3, my lord.
10 is not connected with 9.
No, Your Lordship.
My lord.
Yes. Obliged.
Lordship. Similar prayer for item number 10, Your Lordship.
Yes.
No objection, Your
This
Lordship.
is also same order. Yes.
Oblige, Your Lordship. Please, Your Lordship. Your Lordship, I beg to mention item number 13, Your Lordship.
Yes.
Your Lordship, in this matter, we have to file an affidavit bringing on record the inquiry report, Your Lordship. But the petitioner is on the treatment, Your Lordship. We need to obtain his signature, Your Lordship.
Yes. So what is your prayer now?
Kindly pray for 1 week time, Your Lordship.
This is not coming. Just say, you just do whatever the things, we'll have it after vacation. Right. This also as requested by the learned counsel petitioner, and this is better after vacation. 13. Yes.
Bibli oblige, Your Lordship.
Please, Lordship, I beg to mention item 11.
Yes.
For respondent number 3, Lordship.
That's phone number
3.
3.
Lordship,
And
I
who is
pray that
appearing for the
matter may-
petitioner here?
Mr. Joshi.
Mr. Joshi is there, my lord.
He's not present.
I'll inform Lordship.
He'll inform.
Yes.
Just say, as requested by the learned counsel. Appearing for the response number so and so. This is matter after vacation. Yes.
Oblige,
Deputy.
Lordship.
Your Lordship, I beg to make a mention of part of the hearing, this item number 4 on behalf of T. Yangi, Your Lordship.
Where is T. Yangi?
On her behalf, I'm for the respondent, Your Lordship.
No objection, Lordship.
This also is requested by so and so. Learned counsel for the response number so and so. This is matter after vacation. Yes.
Highly obliged, Your Lordship.
Daily Councillors, item number 1.
Lordship. Mr. Paul is on legs. Lordship may have it at the end of the board.
No, which one? This is not. This is regular list, isn't it?
Apologies. Your Lordships, in this matter, I'm supposed to file my affidavit, Your Lordship. I require a little bit more time, Your Lordship. Your Lordship,
Yes,
I
and-
pray that the matter can come up after vacation.
Nobody appears for 2 and 3.
I am
Respondent-
for 2 and 3, Your Lordship.
appearing on behalf of respondent
You are serving to. You are D. Maori.
I am demarried, Your
So
Lordship.
earlier occasion you filed. Have you filed your vakalatnama?
I have, Your Lordship. I have.
And what is the correction was to be made in the thing? First
To-
title?
Constantly, yeah, Lord. We have correct.
You have corrected.
Yes, Lordship.
What is the correction for?
To
Was it for deletion of
to
names? Some
remove-
names.
To remove from party respondent.
IP.
Party,
Was it done? Corrected?
yes, Your Lordship.
Council say do not bother to check it, isn't it? Okay, just say.
State won't be filing after it.
Hmm?
The state won't be filing after.
The landed counsel for the petitioner. Landed counsel, Miss MS so and so, appearing on behalf of the petitioner. Landed counsel appearing on behalf of the petitioner submits that necessary correction has been made in the cost title of the revision application. Stop. MS D Maury, landed counsel appearing for the respondent number.
2 and 3, Your Lordships.
No, before that you just say MS SCM, landed counsel appearing for the respondent number 1, submits that no objection is required to be filed on behalf of the state respondents in this matter. Next you say MS D Maury, landed counsel appearing for the respondent number 2 and 3. Praise for granted. How much?
After your vacation, Your Lordship.
Praise for grant of some time for filing an objection in the matter. Okay. Then you say anyone else? Any other respondent? No other.
Respondent number 4.
Yes. Are you filing your objection or you have filed it?
After vacation, filing.
So why you are silent then? Mr. So and so, landed counsel appearing for the respondent number 4 also has a similar prayer. Then you say prayer. Prayer is allowed. List is better after vacation. Yes.
Supplementary cost list. Item number 1.
Lordship, Mr. Paul is on legs.
Hmm?
At the end of the board, Lordship.
At the end of the board.
Lordship.
What do you have any other? Just okay. Just wait. Just we have.
Daily cost list. Hearing item number 2.
Please, Your Lordship. Your Lordship, similar matter is pending before the Honorable Supreme Court. As such, I'm praying the matter may be listed.
Yes, landed counsel for the petitioner submits that the similar matter pending before the apex court is yet to be disposed of. In view of the submission, list this matter after vacation.
Oblige, Your Lordship.
Oblige, Your Lordship.
Second call. Item number 1.
Lordship, Mr. Paul is still on legs.
You can start. Or any difficulty in starting?
Lordship, actually, Mr. Thapa is the briefing counsel in this matter.
So he is also not there.
He is also in the other courtroom.
Now you have to tell the counsel for the respondents to open up the case for the petitioner. Yes, Mr. Thapa.
My lord, here, my lord, we were requesting this matter to be put at the end of a board, but I'm informed that
That is the last
the
item.
list is already exhausted.
Yes.
My lord, here, my lord, here on the earlier round of litigation, my lord, I'll take your lordship to that order. Now, just before that, my lord, I'll take your lordship to the brief facts of the case, my lord.
Yes.
Here, my lord, the petitioner's grandfather, my lord, was allotted with a plot of land at RR Colony. For, my lord, as he was,
Allotment was made by which order?
my lord,
And on which date?
18. I'll take your lordship to page 18, my lord. That was made in the year 1959.
What is the name of the?
Mahindra Kumar De, my lord. The particular, I mean, he stands at serial number 15.
Serial number 15.
Yes, ma'am.
Mahindra Kumar De.
Correct.
This is plot number 267.
267.
Mohar, Shillong.
Mohar was his address.
It was his address during that point of time.
Right.
Yes.
Now, my lord, after that, my lord, after these orders were made, my lord, in spite of this order, my lord, there was no clarity with regard to their title over the property, my lord, and as there was no document of title given to any of the allottee at that point of time, my lord, certain writ petitioners by the name of my lord Umpling Rinja Welfare Society, they approached the erstwhile Guwahati High Court.
Just before that,
My lord.
just before that, if you come to that page 18, and if you notice the first paragraph.
Correct.
Now it says, the
Delivery.
second line, they are further requested to receive the certificate of possession
My lord.
from the SDC in charge land settlement Shillong after signing necessary agreement in this office between 10 am to 12 am. Now, was it, is there anything to show that have you received the certificate of possession?
No, my lord, there's nothing as such.
So
my lord,
there is
because
no certificate of possession. You have not, so it means, that means if there is no certificate of possession, that means what?
my lord, here the letter itself says, my lord, delivery of possession. My lord, may kindly see the subject. Delivery of possession of plots.
Yes, that is okay. If you, then you see the contents.
Yes, my lord, the
If you read it,
certificate,
the LOT of the Umpling colony, if you read it,
the allottee of the Umpling colony, whose names are noted below, are requested to approach the executive engineer, RR division, Shillong, and get their plots demarcated by boundary pillar at their own cost. As pointed out by the field staff, they are further requested to receive the certificate of possession from the SDO, IC Land Settlement Shillong after signing necessary agreement.
so delivery of possession is completed once you take certificate of possession. That is what is understood from here. Now, pursuant to it, now whether you were given possession, have you taken delivery?
My lord, possession was taken by us, my lord. In
Yes.
fact, the certificate which your lordship is talking about,
Yes.
my lord, that certificate is not annexed here, but my lord, it is a fact, my lord. It is a pleaded case of the petitioner, my lord, that my lord, most of this certificate concerning this particular
No,
plot.
just thereafter, then you should show us, take us to the pleading where you said that you have taken possession on such and such day, and the demarcation was done. Is there any averment?
No, my lord, there is no averment to that effect.
Then which you tell us to believe?
Yeah, but we are only saying that, my lord, that certificate which were all in my possession was gutted in fire.
That is okay. We understood. It is understood. The only thing is that what we needed is that
My lord, all this aspect, my lord, perhaps may not be necessary in this present litigation. Why I say this is, my lord, on an earlier round of litigation concerning the same issue, my lord, we had approached this honorable court.
yes.
Your lordship will see the order passed therein. Your lordship will have that at page 34, my lord.
Page 34.
Right.
The other documents are not required to be looked into now. The other documents which you appended with your writ petition is not required to be
Not
looked into.
necessary, my lord, because this particular issue has already been dealt by by this honorable court in an earlier round of litigation.
Order dated 26/9/2013.
26 9 months.
Yes.
I'll take you to the first paragraph. The apex court held that it is now well settled law that a party has to plead its case and produce sufficient evidence to substantiate the averments made in the
Reading
petition.
page. Achha, first paragraph. Yes.
Malad. And in case the pleadings are not complete, the court is under no obligation to entertain the pleas. There is a clear distinction between a pleading under the CPC and a writ petitioner to counter affidavit. While in a pleading that is a plaint, I'll skip this part, I'll take your lordship directly
Why?
to paragraph
This
12.
might do not find favorable to you.
Not necessarily, not exactly. I can read it, Malad, there's no problem.
It's all right. It's all right. It'll come to the portion where.
But I'll just come to the portion which is relevant for our purposes, Malad. Para 2, Malad. Keeping in view of the settled law regarding the pleadings of the writ petitioner, this court is taking into consideration of the case of the petitioner that a plot of land was purchased by the central government from the then government of Assam for rehabilitation of refugees from East Pakistan, and thereafter a portion of it was allotted to the grandfather of the petitioner. But in the pleading of the petitioner in the present writ petition, nothing had been mentioned about the particulars of the said land, which included the said plot of land allotted to the grandfather of the petitioner, purchased by the central government from the then government of Assam for rehabilitation of refugees, and the date of allotment of the said plot of land to the grandfather of the petitioner. In the writ petitioner, it is stated that there is a rehabilitation scheme for the refugees from the East Pakistan, but a copy of the scheme is not annexed to the writ petitioner, and also terms of the schemes are not mentioned in the writ petition. It is further stated that the plot of land, that is plot number 267 in question, was allotted to the grandfather of the petitioner on so and so date by the central government through the agency of the state government, that is government of Assam, as the state of Meghalaya at the relevant point of time was not non-existent. Again, a copy of the allotment order is not annexed to the writ petitioner. The petitioner also stated that his father opened a tailoring shop in the name and style of Shillong Tailoring in the said plot of land, plot number 267, but the said tailoring shop had been gutted in fire, which happened in the year 1967, and all documents pertaining to the allotment of said plot of land, that is plot number 267, were also gutted in fire. At present, the petitioner is not staying in Shillong, as he has been employed in the service of the government of Arunachal Pradesh, and as such the petitioner did not occupy the said plot of land, that is 267, which was allotted to the grandfather of petitioner, Shri Mohinder Kumar De. Without any notice, the respondent on so and so forcefully entered into the said plot of land, that is 267, belonging to the petitioner, and took over the possession of the said plot of land and also sealed the same in the presence of the police personnel. On coming to know about the possession of the said plot of land, that is plot number 267 by the state government, the petitioner immediately contacted the attorney, who in turn contacted the respondent and informed that the said plot of land was to be handed over to Presbyterian Church. This court, by an interim order dated so and so, had directed the bodies to maintain status quo of the said land. It is the submission of Sri so and so, learned counsel for the petitioner, that because of the said interim order dated so and so, the government has not taken over the possession of the land, that is plot number 267. The respondent number 2 filed in opposition sworn by Sri so and so Deputy Commissioner East Sales in the present of the writ petitioner, wherein it is stated that the office of Deputy Commissioner so and so had received an application from so and so with a request to allot the government land, that is plot number so and so. On receipt,
What is that? What is it?
had received an application, Malad,
From whom?
from Poxe Presbyterian Church,
Yes.
with a request to allot the government land, that is plot number 267 at Umpling RR Colony. On receipt of
Yes.
Malad, just, Malad, kindly pardon me for a second, Malad. There is one matter. On receipt of the said application, the plot number 267 at RR Colony was inspected and verified, and it was found that the said plot of land, though originally allotted to Mahendra Kumar De, grandfather of the red petitioner, has not been entered into or taken possession of by the original allottees, and no lease agreement had been executed in favor of Shri So-and-so. Until date, no lease agreement had been issued to him. During the process of inspection, my lord may kindly see, my lord, the case that was put forward by the respondents earlier remains the same, my lord. That is, all along they have been saying that we have not taken over possession. Now, during the process of inspection, it was found that the plot number 267 was utilized by the Apanjan Club as its meeting place, and the part of the plot is also being used by a carpenter, a resident of Lumshingai. A transformer of the MECB also stands on the said plot of land. Both these organizations have built structure of hollow bricks and tin roof on the plot, for which no permission has been sought nor given. It appears from the affidavit in opposition filed by the respondent that plot number 267 at RR Colony was originally allotted to Shri Mohendra Kumar De, grandfather of the petitioner. But in the affidavit in opposition filed by respondent number 1, it is stated that the said plot of land, plot number 267, had been already allotted to Oxford Presbyterian Church.
No, but then previous paragraph it says that they have applied. It doesn't say that it has been allocated.
Yes, they say that it has been applied. It was applied, but because of the status quo order passed by the Honorable Court,
yes,
no further
no, but then
action could be
this
taken.
paragraph, it says the plot of land has been already allotted to Oxford. Okay. Yes.
That is, they say, the respondent says so.
Yes.
Mr. So-and-so, learned counsel for the petitioner, contended that the inquiry had been made through RTI if the plot of land has been allotted to the so-and-so, and in such inquiry it is found that the plot of land has not yet allotted to so-and-so. Mr. So-and-so, learned counsel for the petitioner, also contended that this court, in the civil rule number so-and-so filed by one society formed by the members of RR Colony, whose case is similar with the case of the present petitioner, had directed the government of Assam and the central government to undertake the exercise of verification of the right of the respective occupants of the government land under the rehabilitation scheme of the central government. In the process of such verification, the relevant officer under Relief Rehabilitation Department and also senior officer of the central government in the Ministry of Home Affairs shall also be associated. If the Deputy Commissioner of Government of Meghalaya is satisfied that the right of the occupant of the land in question, the Deputy Commissioner of the Commissioner of Government of Meghalaya shall issue patta lease to the occupant. After careful consideration of the submission of the learned counsel for the parties, it appears that plot number 267 was once allotted to Mahendra Kumar De. In such circumstances, the state government, without following due process, cannot allot 267 to any other.
What is the due process?
Well, there has to be a notice issued to the person concerned.
On what basis? Notice issued to a person concerned, like, say, supposing
to whom it was originally allotted, my lord, there has to be a notice issued. A due opportunity of, my lord, placing my
supposing
case.
If original allottee doesn't take over the possession, then what happens?
But here it is never a case pleaded, my lord. We have never take over. This is a disputed question of fact.
Pleaded. That is what they have said.
That is why I am saying,
that
my
is
lord,
what has been
this judgment, my lord, takes care of that aspect also. Whether I have taken over possession or I have not taken over possession, my lord, that aspect, my lord, is already taken care of by this judgment. Has been dealt with by this judgment, my lord.
But where does it say? Does it say that you have taken a possession?
No, my lord, we say that it has been taken possession.
Complete. Please complete the reading.
It cannot be to any other person. Therefore, the respondent number 1 and 2 are directed to conduct an inquiry to find out if the said plot of land 267 was allotted to the petitioner's grandfather, and if allotted to the petitioner's grandfather, necessary follow-up action should be taken up in accordance with law. My lord, here the Honorable Court on an earlier round do not say, my lord, do not really dwell into
nothing about possession. It is
nothing
whether
about
it is allotted or not.
Yes.
And if it is allotted, then you follow the due process.
The presumption that would go in my favor would be, my lord, the court already held that the possession is there.
Well, may not go to
Now
that
the
extent.
only aspect that remains to be decided by the respondent is whether.
Why to stress the order beyond what it is said?
My
Let
lord,
us-
that's the
if
only,
we-
because my lord, then I would harp, my lord, the doctrine of sub silentio will come into play when it comes to this particular judgment, my lord. Because that was their plea in its entirety, my lord, we were never in possession. The Honorable Court, having dealt with that particular my lord, objection, if I may put it that way, having dealt with that objection, my lord, that we are not in possession of the property, my lord, passed this order. So, my lord, the very much the doctrine of sub silentio will come into play, because, my lord, the Honorable Court, after considering their objection, passed this order. So, in the opinion of the Honorable Court, my lord, the aspect of possession, my lord, is either, my lord, has not been dealt in writing, my lord, in black and white, but, my lord, that having considered, my lord, the Honorable Court passed this order, which goes on to
So that is
mean,
implied. The possession part is
yes,
implied.
they go on to mean, my lord, it is something very immaterial for the purposes of the adjudication of this matter. That is why the Honorable Court held, my lord,
See,
that
Mr.
whatever,
Thapa, just sorry to interrupt.
my lord,
If you see, at the initial part of this order, the court has held that no allotment order was appended with the petition.
correct.
Here, it is not the case. In this present one, you have brought forward, you have enclosed a copy of allotment order in this writ petition.
Correct.
The situation was different there.
So
Now,
that order was
see,
there, my lord,
since
in the
there
earlier writ
was
petition.
no evidence of allotment appended with the writ petition, the court had on earlier occasion has passed an order to conduct an inquiry to see whether this allotment was made or not. Now let us assume, let us admit, rather you can say, that allotment was made. But then a further ground comes now to determine your right over the plot, that whether you have taken at all taken over possession. The paragraph, the first paragraph of that allotment order, which speaks about taking possession, certificate of possession, that was not before the court at the time when this earlier order was passed.
No, that allotment order was there, my lord.
No, but then
That allotment order was
see
there.
the observation of this court you have seen. It says what it says.
It appears that 267 was once allotted to Mahindra Kumar De.
It appears from the amendments. It see just a minute before that. See, come to paragraph 3
Paragraph, my lord.
of the page 36 of this order.
My lord. Paragraph 4.
Paragraph 3, page 36 of the writ petition.
Correct.
You've seen. Come to the middle.
Yes, ma'am.
See again a copy of the. You see, it is fifth line from bottom.
Copy of the scheme.
Again, a copy of allotment order is not annexed with the writ petition. Go through this paragraph. Now that was the situation. Anyway, it's all right. Then what happened? This court required, the High Court required that state government should verify and pass an order, isn't it?
Yes.
Now what order was passed pursuant to this direction?
My lord, then they made an inquiry, my lord.
Yes.
Which you also will find at page 42.
The direction was to hold an inquiry, isn't
Inquiry, my lord. And only to the aspect of whether the allotment was at all, I was allotted with a plot of land or not. And not to the other aspect, whether I was in possession, whether I have taken, signed the agreement or not. Those aspects were never, my lord,
it is untouched. It was not touched.
yes, the court,
It was not
honorable
dealt
court found that it may not be necessary for the purposes of the issue that they were dealing with at that point in time. But I'll take your lordship to page 42 now. the depositions in brief are reproduced below.
This is the inquiry report.
Inquiry report.
Yes. This is dated?
This is dated 26/9/13. Oh, sorry, I'm wrong. The inquiry report is dated 19th February 2014.
Yes.
Shri Mrinal, my deposition was also taken.
Yes, because the High Court's order said that you should also take.
Absolutely. Petitioner has at Annexure 1 stated that his grandfather Shri So-and-so was a displaced person of East Pakistan and came to Shillong for shelter, enclosing thereto a copy of notice on delivery of possession of plot to the respective allotted umpling issued by so-and-so, dated Shillong so-and-so, to prove that his grandfather had also received the notice at serial number 15 in the name of so-and-so by the Relief and Rehabilitation Officer, United Khasi and Janjia Hill, Shillong, and accordingly his grandfather took possession and received the possession certificate of plot number 267. The petitioner further stated that as far as other documents are concerned, he had already submitted the same to the Office of Deputy Commissioner East Khasi Hill, Shillong, and lastly he stated that he being the employee of Government of Arunachal Pradesh, he expressed his inability to attend the court as and when required, and hence appointed so-and-so as a power of attorney. Now, Your Lordship, in the process of inquiry, my lord, although the Honorable Court had directed a fresh inquiry, my lord, what the respondent did was, my lord, they relied on a piece of statement, my lord, which was taken even prior to the judgment, and based on that particular, my lord, statement, my lord, they gave this report. They mainly relied on this particular statement.
Is it?
Yes, my lord. Now, kindly see page
there
40.
definitely is a law with regard to this. Probably there is a recent decision with regard to this.
Well, I'm not aware. I'm sorry. I have to candidly admit, my lord, I'm not aware.
That is your ground. Then you should.
No,
See,
I'll
the
make an
inquiry, the statement made earlier on some different occasion was relied upon. Now, probably bit of all is there actually. See, any law with regard to that,
There is.
that it cannot be relied
Cannot
upon.
be. That vitiates the entire inquiry.
You find it out then.
You do the needful. If there is a judgment, well, please that judgment.
Clear judgment of this.
I'm
These
sorry,
are
my
the
lord.
little, you see, ray of hope so far as your case is concerned. You have to be on those things.
I'll please those judgment, my lord. I'll do a bit of research on that.
Anyway, proceed with this. This is one ground that
The statement, my lord.
where is that part? Where is that part, please?
Your lordship will find it at page 43, paragraph 3.
Page 43, paragraph
3.
Yes.
Shri N. Bhattacharya, President of R&R Colony Welfare Society, had made his statement on 23/9/2009.
That is on some different occasion.
On a different occasion also.
Yes.
As per Annexure 3, stating that he is a lessee of plot number 12 and staying in Umpling Aran Colony since 1963. At that point of time, there was only a wooden structure with a tin roof standing on plot number 267, and do not recall if anyone was living in this plot of land in those days. He also stated that NGO and private workshop are established inside the plot without authority, and hence stated that he do not think if anyone claimed the land for the purpose of residence. Thereafter, officials or non-officials or individuals who were associated some way or the other to the plot number 267 at RR Colony had not come forward to appear before the undersigned for the purpose of adducing evidence and recording of deposition, and hence closed the inquiry on 30th January 2014. My lord,
Mr. Thapa, another aspect is there. Normally, the proceedings of a record of one case can be relied upon by
yes, my lord.
the court in a different proceedings as per provisions of evidence act.
My lord.
the evidence adduced during the course of one litigation can be taken into consideration by a court in a different litigation. That is the law.
Correct.
Will it not come under that?
It won't, my lord, because
That
here
can we apply the same analogy when it comes to recording of evidence in inquiry proceedings?
well, the statement which we were talking about that was taken on 23/9/2009
Yes.
doesn't talk about on what occasion this statement was taken. They simply say that the statement made on so and so date.
So do you want
what
to say
proceeding-
there exists?
And in what context, what proceeding, my lord, it doesn't talk about anything.
So do you want to say that this statement doesn't
Just
exist
a
at all?
random statement taken from my lord, anywhere, my lord, would not
So you have to first see then where it was made.
absolutely. My lord.
No, but then it says that it was made on 23/9 as per Annexure 3. What is that Annexure 3?
And that annex, my lord, those annexes were never supplied to us. We were only supplied with the inquiry report.
This Annexure 3 is supposed to be part of this inquiry.
Yes, my lord, supposed to have been given, but that was never supplied to
You
us.
have enclosed all those things, Mr. Khan, in your affidavit in opposition.
Yes.
This Annexure 3 and all will be there.
No, we have not annexed the lordship. We just annexed the inquiry report.
That was never given. My lord.
No, you
Lordship,
say that we must see that this statement was given on in what proceeding,
Lordship,
what is the context, then
this-
definitely we should see.
If we can produce the record in the first round of litigation, this was there. That statement was there. It was part of the record. As rightly Lordship has said, just to answer this query, this statement of 29/9/2006 is an affidavit given by the Secretary of.
Because see, Mr. Khan, since there is a judgment by this court in earlier round of litigation, where it says that you hold an inquiry to determine whether any allotment was made to the father of the petitioner or not. Now, if there is an inquiry, then definitely then the other aspects, which you say that no possession was taken over, okay, no right will accrue.
Lordship, can I just
Because this
no?
judicial order will support.
Can I just reply, Your Lordship? For the moment, even if you overlook this Annexure 3, this is immaterial, Lordship. It does not either confers any right on him, neither it takes any right away from the state. It is almost like a kind of additional piece of evidence from the Secretary. What is relevant for the purpose of the query that we've raised, Lordship, will kindly come to page 44, clause 4 of the inquiry report.
Anyway, we'll come to that. We'll just see. So, if it is a reply on merit, definitely we'll.
No, not on
after Mr.
Lordship.
Thapa finishes-
Kindly have this page 44, clause 4.
We'll see it definitely once Mr. Thapa finishes.
It's a part of the same inquiry report, page 44, clause 4.
Anyway, Mr. Thapa, proceed please. Now, the inquiry, you say reliance was played on a statement which is not recorded during the course of the inquiry.
Absolutely.
So, that is not allowed in law. You have to give us law then.
We'll do it. We'll do the needful.
Because this court doesn't know anything about this laws and all. So, you have to tell us. Okay. Now, was it the basis of the statement was the basis of the finding coming to, of the was the basis for recording the finding in the inquiry? Anyway, you can proceed in your way, Mr. Thapa. Please come next.
Well, I'll just read paragraph. I mean, the last penultimate paragraph of page 45. And on the other aspect, my lord,
Yes.
Lord, and the other aspect, my lord, there is nothing on record to show that the respondent made an endeavor, my lord, to reach out to me by way of a notice or otherwise, my lord.
But then you appeared.
Even by way of no, my lord.
You appeared here. You see, that has been your statement has been.
Yeah, no, not this one, my lord. I'm talking about my lord, pursuant to the allotment order. there was nothing on record to show, even by the
That
respondent.
part is gone. We have come over those things.
I'll just take your lordship
You
to-
have to show that right now your duty is that you have to show that you are in possession.
Yeah.
See, if that point of view say that they have never tried to reach out to you, and that will prove that you have never taken possession.
Well, I'll take you to paragraph 7 at page 44.
Yes.
The father of the claimant, my lord. This particular noting, my lord, observation is completely perverse.
Yes.
The father of the claimant, Mohit Lal De, was a registered refugee. They accept, my lord, that I was a refugee.
Okay.
Yet no allocation of plot of land at our colony was made in his favor. My lord, all this while we have been harping on only one aspect, that is, my lord, and it is an admitted position that was the allotment was made in my favor. My lord,
No,
here
but to his grandfather only.
made in his favor, but to his grandfather.
Yes, just
My lord, so they admit.
let us complete the reading.
My lord, I'm sorry, my lord. So they admit, my lord. They admit the fact, because your lordship will, if I may take your lordship back to the honorable court's order earlier. My lord, the only aspect that was considered by the honorable court and a direction to that effect was issued is to find out if the allotment was made to my grandfather or not.
And then to proceed in accordance with
In
it.
accordance with
Now-
which they admit in paragraph 7 that it was allotted to my grandfather.
No, it was anyway. This is yet okay. And then let us finish. Let us finish the reading.
Yet no allocation of plot of land at so and so was made in his favor, but to his grandfather, which creates a doubt. The plot number so and so remains vacant for a period of more than 46 years when the claimant claims of his inherited the property without any documentary evidence. Now, my lord, from where this observation came that it remains vacant for the past 46, there is no evidence to that effect in the inquiry report.
And then
The government, after following due procedure of the concerned issue, had accordingly instructed the Deputy Commissioner Shillong to take over possession of the said plot of land, white letter dated so and so. Now, my lord, what procedure has been followed? My lord, like I said, my lord,
the High Court's order
what are the
was
documents that were
basically
relied on?
confined to recording of the finding whether allotment was made on it.
Absolutely, my lord.
Now it seems there is no direct answer to that.
But they
He
admit
said that allocation of so and so was made in favor was the one was a registered, yet no allocation of plot of land at our community was made in his favor, but to his grandfather.
right. So they admit the position.
So that
my lord.
is one way.
It's an
you can
admission
say
on
that
their part.
Allotment was made. Now, just stop for a moment. Now, High Court says that if allotment was made, then necessary procedure should follow. Now, what are those procedures which has to be followed?
Then they have to issue patta in our favor, my lord, then.
Where is that?
In
On
terms
what
of,
basis you say?
my lord, if the allotment is made
Now,
to me,
necessary procedure. Your case, earlier case before the High Court,
right.
was for what? What was the prayer there?
Well, in the earlier, our prayer was to issue patta in our favor only. And my lord, we also challenged the action of the state correspondent in taking over the plot of land, without any due notice to us. Now,
No, it doesn't. The order doesn't say that if it is you are found that allotment has been made, then patta should be
no,
allotted
they
in
say
your
the
favor.
due process of law has to be followed. In that, after then, my lord, we will have to follow, my lord, the
Now,
direction.
what is the necessary follow-up action
21.
be taken in accordance with law?
Yes.
What is that?
Now, my lord, the procedure that one would have to follow, if it is established, my lord, the allotment is made to me. My lord, that answer you also will find at page 21, the judgment by the earlier erstwhile, my lord, Guwahati High Court.
Page 21.
Yes.
That is case by Welfare Society.
Yes.
Yes. Have you enclosed your copy of writ petition earlier, the writ petition which you filed?
No, my lord, we have
Then
only
earlier
annexed the
proceedings.
judgment.
Now, if that was this 1999 decision is by this in a petition filed by the Welfare Society on behalf of all the
All the residents,
including you.
including me, my lord, because I was also a
Then
part
what
of.
was the need for you to file a separate case for asking for this thing?
My lord, because like I said, my lord, after this order was passed, my lord, I was not in Shillong for a considerable period of time. And like I said, my lord, I was in Arunachal Pradesh for the purpose of my employment. And pursuant to this order, my lord, there is nothing to show, my lord, the notices to me was ever issued pursuant to the judgment by the respondent.
No, if you
Whereas
come
it
to
is
the
a categorically mentioned, my lord, what is deputy commissioner required to do pursuant to this order.
that is, see, direction in 1999 is bit different, not what exactly what
No, my
was
lord,
passed in your case.
the only thing that
It says in 99 it says that if the deputy commissioner of government of Meghalaya is satisfied of the rights of the occupants of the land in question.
right.
So that is further beyond, not confined. Your thing was an allotment, confined to the allotment.
My lord, my right is already there. It is an admitted position, my lord. My grandfather was a refugee. Allotment was made in his favor. So the right is already created.
But
my
then
lord.
there is nothing to show that you have taken possession.
Now I take
So your right, it is to be if it is to be determined at this stage, then the possession becomes essential factor. It becomes an essential factor.
my lord, my lord, we all along have been saying that we were in possession, which was contradicted by the respondent, my lord. Now, in that factual context, my lord, that judgment by the honorable, by your lordship, I mean by this honorable court, came to be passed. Now there, we were only required to show whether it was allotment was made in my favor or not, and that they have not disputed.
See, if you take shelter of that
Now,
99 that civil law, the order of the passed in our order passed in civil law number 147 is from 1999. Then probably again things become a bit difficult for you. If you say that you are seeking protection, see, and probably your order, and since this order basically this WPC number 370 is specific to you, so that will apply to you.
right.
If you see if there is any inconsistency in direction in the first order and the second order, then the order which is passed in your case that will apply to you.
Apply to me.
Is it correct? That is where what is the necessary follow-up action?
Now, my lord, follow-up action would always be to, my lord,
Follow-up
affirm.
action. Let us see what was your challenge in the first writ petition.
Well, I think
You have not appended the
I have
earlier
not
writ
appended.
petition.
We
with your-
only for the
any statement in your present writ petition, you filed earlier writ petition
yes, no,
with
it is
what
there.
prayer?
The prayer.
We have to determine what is the follow-up action. Otherwise, it's difficult.
No, the follow-up would follow-up action would obviously not be to, my lord, dislodge me of my right, which, my lord, which can be done after confirmation or after holding that the allotment.
That is
was
what we
made in
want
my
to
favor.
see. What was your challenge? You see, your challenge in the earlier writ petition was against any eviction order or the allotment order to them, or was it simple with prayer for grant of patta in your favor? Now that becomes important. If you say like they are bound to comply to the order passed by this court, then in such a case, definitely.
There's a amendment to that effect, my lord, at paragraph 9. perhaps to bring clarity, we might also have to bring the copy of the petition on record. We say that, my lord, at paragraph 9, that as the land in question is a plot of land which was purchased by the central government from the then government of Assam for the purpose of rehabilitation of refugees from East Pakistan and thereafter allotted to the grandfather of the petitioner, and in such scheme of things and events, the respondent had no authority under the law to forcefully take back the said property, and that without following due process of law. As such, the petitioner being aggrieved with the state respondent action, approach this honorable court by way of
it is apparently seems it is against, like
forcefully taking
dispossessing you or maybe forcing or taking over the thing. It is not confined to the issues of patta.
Exactly. Not confined to it.
There is a definite cause of action for you for actually approaching this.
Yes, ma'am.
Now, if that was the thing, then the High Court's order, which says the follow-up action has to be construed accordingly. That means if you are found to be allotted, then the procedure prescribed.
My possession should not be disturbed then.
Wait. Then the procedure prescribed has to be followed. Now the question is, what is the procedure?
Well, in my humble and respectful submission, my lord, it would be my lord, to see, my lord, that the land is now, my lord, bestowed on me accordingly, my lord, by way of issuance of patta or otherwise.
Mr. Khan, just tell us one thing. Just do not go here there. Now, your inquiry says that the land was allotted to his grandfather.
Lordship.
Is it correct?
Lordship,
if you say land was allotted, we are not saying that possession.
Lordship will just come to the inquiry report.
Do not take us to anything else.
No,
Mr. Thapa has not finished. Just for clarification, this court is asking you that question.
Lordship, can you come to that?
Yes.
Lordship, can you come to page 44?
Yes.
Lordship was reading para 44, page 7, para 7.
Yes.
The father of the claimant so-and-so has resisted refugee, yet no allocation of plot of land was made in his favor, but to his grandfather.
Which creates a doubt because of the fact the grandfather was never registered a refugee.
Lordship, allow me to just clarify this part. Now, it is everybody's case, Lordship. In petitioner, state and them, I am sure court also will be in the same page. Nobody is denying that allotment was not made to the grandfather. So, I think we are in the same page. And Lordship had read up that paragraph detail. Kindly get the certificate of possession.
That is so far as the allotment.
Lordship, I am only into the allotment part. I will not go into any other issue. And that was the direction by the trial, by the first round of litigation. If allotment has been made, now we have to answer the query whether what is allotment and when is the allotment completed. The problem came as to letter issued and when will the allotment be completed. That we find it from that annexure 8. Now, if you want to answer that query, Lordship, letter was issued to the grandfather, we can use the word allotment, letter, it's subject to certain conditions being fulfilled.
Annexure 8. What is Annexure 8?
Annexure 8. The type copy is at page 19, Lordship.
Page 91.
19.
Oh, that is the allotment order.
Lordship,
no,
yes.
that is all right. That is we have seen it.
So, Lordship, I am only addressing the issue of allotment. That's why I said every one of us in the same page so for the word allotment is used, the word allotment. Since there is no dispute, there is no point of arguing on that and no point of reading that para 7 of the inquiry. But the issue is whether the allotment word is conditional or in itself, by use of the word, it will confer any right to the father. The next page 19 says
it is conditional.
Conditional.
We know, Mr.
Lordship, now Lordship will kindly come to page 44, clause 4. What is the consequences? Now, if it is a conditional, then what happens if there is the conditions are not fulfilled? That has been answered in the inquiry report.
So let Mr. Khan, let Mr. Thapa complete.
No, Lordship, allow me to just
Otherwise,
conclude. Allow me to
he
just
has not
conclude.
completed.
Only on this issue.
We
Only
got this point.
only
We got this point. It seems to be the crux.
Lordship, only correct. Lordship,
That
kindly
is
allow
very
me to
important.
close this point. only.
See,
Just
like
close this
now, if you have to find out what is the necessary action as meant by the
Certificate.
order passed in the earlier, so that is issues confined. As you say, that is whether it is unconditional or it's a conditional.
Lordship, what is the consequence? I'll just close my submission. Lordship, kindly come to page 44.
You
Clause
have
4.
not started issue. You have not started. Why you are in a hurry to close it?
No. The issue of allotment. I just want to close this. Since Lordship has put the question to me, answer on specific. Let me just close my specific query by reading only paragraph. I'll just crave the leave of the court.
Yes, sir. Please.
That the Additional Secretary to Government of Assam Relief Rehabilitation White Letter dated 18/9/1958. We have annexed this in the additional affidavit before the court.
Yes.
Stated very clearly that the allottee is to sign the acceptance form and return the same to the office immediately. If no acceptance is received within 30 days from the date of issuance of letter of allotment is crucial, Your Lordship. The same will treat me as cancelled. By operation of law, within 30 days from the Annexure 8, his rights stood extinguished. This is the finding of.
Now, that is the 30 days. Then what it says next? Just continue the next line. White so and so.
White so and so, the age of petitioner as on date of his deposition in inquiry officer is stated to be 46 years. As 6/1/2014, meaning that he was born in the year of 1968 or so, which is 10 years more or less than the issue of the above letter during the year 1958-59. Petitioner means not the grandfather.
What the age has to do here?
I don't know why was it. I'm not going into Lordship. Lordship has asked me to answer the query. So, very important thing is Lordship is Annexure 8 is, it is conditional. If condition is not fulfilled, the allotment itself stands extinguished. The right stands extinguished. Nothing survives. So, insofar as grandfather is concerned.
Yes. Yes, Mr. Thapa.
My lord, the other aspect is, my lord, may kindly see the allotment order. My lord, in the absence of any withdrawal or revocation of this, my lord, this allotment order still stands. My lord, it is not a case, my lord, that subsequent to me not coming forward, my lord, to execute the letter of acceptance, my lord, this allotment order was withdrawn.
No, but then what is the stipulation made in the allotment order itself?
It was a conditional, my lord. My lord,
So
here we are saying that everything was done, my lord, but those documents was gutted in fire, my lord. That's why we have not been able to. There is a statement to that effect, my lord. May kindly see the order, my lord. The earlier judgment, my lord, 26/9/2013. At para 3, my lord. We say that, my lord, the letter of acceptance was executed.
para 3.
Yes.
But then was there a finding on that? Maybe in your submission.
There is no pleading in the writ petition.
All documents pertaining to the allotment of the said plot of land. That is plot number
But then
267.
see, the court has said that they have not this thing, enclosed a copy of this thing. So paragraph 3 doesn't help you in. Now see, there are, so far as your argument is concerned, there are two things. One is that this inquiry officer has relied on a set of statement issued or recorded
At an earlier
during,
point of time.
maybe at a different time, which according to you
Could not have
could
been.
not have been relied upon. You have to please give us a law on that.
My lord.
So far as the inquiry is concerned, that will definitely put a question to Mr. Khan. Okay. The next thing is allotment. So that stands more or less.
Well, I would also like to put my,
See, there are two things. If you see the scrutinize this inquiry report properly, you will find in the inquiry, in the last paragraph, it has been held that no allotment was made to your father, though he was a registered refugee. That means he came from. And so far as your grandfather is concerned, in whose name it was issued, he was not a refugee. The question of
No, he was a
allotment-
refugee, my lord. Grandfather was a
that
refugee.
is not. That is what the meaning of that last part of the paragraph of the inquiry report. Come to that
My lord,
inquiry
if
report.
grandfather was not a refugee, the question of allotment would not come in first place.
So that is what. See, that is what has been doubted. See, that is why. That is what.
Mohit Lal De, my lord,
What is,
the
what
father
is
of the
it?
claimant. Mohit Lal De is my grandfather. Oh, sorry, father.
What is that another order, Mr. Oh, there is a contempt. There is a contempt filed by you.
Yes.
Come, read the paragraph 7. What does it say?
The father of the claimant, my lord, Mohit Lal De, was a registered refugee.
Yes.
Yet no allocation of land, a plot of land at RR colony was made in his favor, but to his grandfather,
Yes. Which created doubt.
which creates a doubt.
So that means your grandfather was not the registered refugee.
No, my lord, it says that the allocation was made to my grandfather.
Kindly understand.
Right.
This scheme was for accommodating refugees. So only the refugees were entitled to be allotted.
Correct.
Now, what has been held in this inquiry is that though your father was a refugee, no allotment was made to him.
Oh, yes.
But then allotment was made to your grandfather. And then he was not a refugee.
In that event, my lord, this particular finding is even more perverse, my lord. Because
it's all right, we are not going to
I
destroy
will not be a refugee unless unless my father is a refugee.
That we do not know. But then you have to be enlisted.
I would not come unless my father comes.
By the normal logic. But then you have to be enlisted. See, for allotment, there has to be enlistment.
Correct. My grandfather was enlisted.
So your grandfather did not appear to be a registered refugee. He can be a refugee, but then he was unregistered.
Then we'll have to again come back to my lord.
Anyway, you see, that is all right. That is all right. We got your things now. At least these 2 points. It seems to be two points: that allotment part and that statement in the inquiry.
And my lord, whatever is being stated here in the,
but then this court
especially the observation, my lord,
would have liked to see this earlier round of the copy of the your writ petition, the earlier round of it.
We'll place that on record, my lord. No.
When you'll place it? Tomorrow.
Tomorrow will be little. Let it come next week, my lord. Any date.
Next week, everything next week will be.
When ultimate week.
Monday.
But only for the purpose of it can be Monday.
And Mr. Khan, what about that part? That's Reliance placing reliance on the statement recorded on some other occasion in an inquiry.
But it's not an oral statement. It relies on the record. So the reliance is on the record. Annexure 3 is the record.
How far it is tenable?
Lordship, there is no finding based on that record. Had there been finding, then it could be in a previous, and court will step in only for the purpose of.
See, they have taken into consideration that part that he was not in possession. That entire statement was with regard to that.
Lordship, that can be overlooked. Or court can, for a limited purpose, court can send the matter back to the inquiry committee and say you disregard this and pass an order. Court will set over a judicial review.
You are agreeable to that? Will interfere with these things. We will send it.
Lord, that would again be
no only so.
No, we will say to consider the matter minus the statement.
Then he'll come back
to. He is agreeing to what you have raised.
It should not be something.
Then this inquiry report will go what he is saying, and we will send it back for passing fresh order. We'll come to you, Mr. Linda. Do not get worried. We will not pass any order without hearing.
No, Lordship, that is one part of it. Now, my second part of it is, Lordship, whether finding was basis on that annexure 3. Then
if you say that solves the problem, if that is the thing, then we will record it now.
But Your Lordship, the finding is not based on that statement. It was just recording.
That's all right.
There's no perversity.
If you say that you are open for that thing,
I'm open into Lordship. I'm open into it, but I'm not saying for the moment. I'm not closing my argument on that. I'm open into it. But so far record is concerned, then there is no bar, except he shows a law that there is a bar. There is no bar for the fresh inquiry committee to rely on a record.
Yes, Mr. Lindo. Yes. What is?
Please. In accordance with the submission of my learned friend, he has approached this honorable court for a couple of possession. But however, Your Honor, this is a list prepared in which they are relying. penalty will be upon delivery possession. However, Your Lordship, I would like to draw your attention towards the chronology of timelines and events.
Why don't you come this side? Come. It will be better. We can hear you better.
Yes.
Come here. We have to take you straight on. Yes.
Yes, Your Lordship. I would like to draw Your Lordship's attention to the chronology of events in accordance with the pleadings. Lordship, I have just prepared for myself to assist the court.
Have you supplied a copy to them?
No, Your Lordship. What?
You should have supplied.
Yes, Lordship, but I have
want us to look into something, then you should.
No, Your Lordship, but it's in the pleading itself, Your Lordship. The entire.
It's all right, but then you see, whatever you prepare, whether it's a gist or notes, whatever it is, you should supply a copy to them. Supply as a copy. Supply them a copy. Let us see what happens.
Lordship, may I? I'll draw Your Lordship in accordance with the paragraph in the intermediate petition.
Of the writ petition.
Yes, Your Lordship. Now, Your Lordship, the petitioner here claims his grandfather to be a refugee, Lordship, in accordance with the refugee certificate, Lordship, which is.
One, just give me 1 minute.
Yes, Your Lordship. Yes.
Yes, please.
Yes, Lordship. Lordship, at first instance, a refugee registration card, Lordship, which was claimed to be issued, which is Annexure 1, that is dated 30/12/1950, Your Lordship. This is the first document, at first instance, they are relying, Lordship, a document. And from the pleadings, Your Lordship.
One.
Page 17, Your Lordship, is the type copy.
Page 16.
17. 16 is the photocopy.
Yes, that is.
17 is the type copy.
Yes.
13/12/1950.
Mohit Lal is the father of the.
Yes, Your Lordship. And Your Lordship, in accordance with the pleadings of the petitioner, claim, Your Lordship, which is at paragraph number 5. That the petitioner states, in the meantime, the father of the petitioner, late Mohit Lalde, got a job for medical department as Maria Sunsu and Nafa on 27/3/1953. Page number 8, Your Lordship, paragraph number 5.
Paragraph number 5.
Yes.
Yes.
So there's no way of mentioning of the grandfather, Your Lordship, where he is, and upon his demise, where he is, Your Lordship, in accordance with the pleadings of the petitioner. And the notice of delivery of possession of plots, Your Lordship, that was pronounced by.
What you are trying to submit here?
Your Lordship, maybe, Your Lordship, I'll just come to the delivery of possession, which is.
Yes, that is not more relevant to me. But then what was your
the relevancy here in Your Lordship to correct the dots and the circumstances, Your Lordship. 1953, he already left for Nefa for work, Your Lordship. And what about Mohendra Kumar De, Your Lordship? There's no way of mention in the pleadings anywhere.
We are not onto these things.
Yes, Your Lordship. Let me come to the point, Your Lordship. The circumstances to connect the dots, Your Lordship. And now this delivery possession, upon when he left Nefa, Your Lordship, for Nefa, for work, the rehabilitation, this letter dated 24/11/1959, was notified, Your Lordship. So whether he's present here or not, Your Lordship, that is the matter of concern.
See, possession was to be taken by
yes,
his
Your Lordship.
grandfather.
Yes, Your Lordship. And Your Lordship, there's no way mentioned where the grandfather is. But except the father.
Mr. Lindo, please, one thing. We are in a writ jurisdiction.
Yes, Your Lordship.
It may not be like in appellate court, we will go and appreciate this thing, that thing. You just tell us, so far as we basically decide on the matter on the documentary evidence.
Yes, Your Lordship.
See, there is a document which says that allotment was made to the grandfather.
Yes.
Now, whether that was a right allotment, wrong allotment, we are not deciding that question. Not at all confined to that. Now, your case is that even though there was an allotment, no possession was taken out.
Yes, Your Lordship.
Okay, no position was taken over by this.
Yes.
So, and then if there is if they do not take over any position, no light will left. That is what your
Yes.
case is.
Yes, Your Lordship.
Isn't it?
Yes.
So that is what the content seems to be continued, what Mr. Khan said.
Yes.
Okay. Now the problem is, or not problem, rather you can say that the issue is the passing of an order by the High Court in the earlier round of litigation.
Yes. This is my
Now,
first
where
round of
it
litigation.
has ordered for an inquiry. And said that depending on the outcome of the inquiry, you take follow-up action.
Yes.
Isn't it? Now that was passed in a case where they sought protection against eviction.
Yes.
Isn't it? Now, inquiry was done. The finding is there that allotment was made to his grandfather. Now, if that be the thing, what would be the follow-up action? That is the main thing. We
Yes.
have to on this.
Then, Your Lordship, let me put for just my position in the case, Your Lordship. I was arraigned as a party only in 2021, Your Lordship. Then I filed my affidavit. In my affidavit, Your Lordship, I have filed and relied on certain documents, Your Lordship.
You have been lately implemented.
Yes, Your Lordship. At a very late stage, Your Lordship. So my contention in Your Lordship, in the first round of litigation, in accordance with judgment, whatever the judgment that has been delivered, the 2013 judgment, Your Lordship, there's nothing on record to show, except document they relied upon, Your Lordship, is the civil rule.
Do you have a copy of their earlier order of writ petition? Mr.
I have
Khan
just
or
the
anybody?
order. I have just the order of which was annexed, Your Lordship, relied by the petitioner. Now, Your Lordship, during the course of the proceedings, I have brought on record certain documents which I have received from the Assam Archive government, Your Lordship, and I have placed that on record, Your Lordship. I have
Yes.
filed my
You write
affidavit in July 2023.
Yes, just a minute. Let us come to that. July 2023. 20th July 2023.
Yes, Your Lordship.
NDD Nangnam. Yes.
Yes, Your Lordship. Your Lordship, in this document, a list in accordance that I have relied, Your Lordship, which is Annex B, page 8 of my affidavit.
Page 8.
Page 8. Your Lordship, in my main affidavit, Lordship, my affidavit in the position, dated in July 2021.
Dated 19 July
2021.
23.
21, Your Lordship.
Your main affidavit position. How many affidavits you have filed?
Just two.
Just two. You wanted
Yes.
to file some more?
No, Your Lordship. I'm relying on this
You
document.
said just two, that is why. There's so many affidavits in the petitions. Yes.
Yes, Your Lordship. Annex B, I have relied on certain list of allottees at RR Colony.
Page 7 and page
Yes,
8.
8, Your Lordship. Yes.
Page 8.
Yes, Your Lordship. Page 8. The series of.
What is this? The list of allottees.
Yes, Your Lordship.
Yes.
And Your Lordship, may kindly refer to the affidavit dated 19 July 2021. It is connected, Your Lordship, with the document that I'm relying upon.
This is not incorporated in one.
Yes, Your Lordship. And these
One
lists,
affidavit.
in these lists, Your Lordship, they are in tally and it goes in line with the document that I'm relying.
In this list, where the name of the petitioner is there.
No, Your Lordship. It's not there.
There are 36 allottees. Oh no, more than that, 77.
More than 200, Your Lordship.
This is prepared when, this list?
This list, Your Lordship, I have obtained copy from Civil Rule 147 of 1999.
This when this list was prepared, and who prepared this list?
Nothing mentioned.
The rehabilitation. This is in connection with Civil Rule
We
147
understand,
of
but then
1999.
who is the maker of this list?
I do not have knowledge, Your Lordship, of that, but I have
You
applied
are
copy
enclosing
from.
a document in your affidavit, and you say do not have knowledge.
Your Lordship,
must
these
have
are the
knowledge.
documents which I'm relying upon, which is in accordance with the Civil Rule 147 of 1999, which I have
Yes.
applied copy from the court, Your Lordship, from the registry. Your Lordship.
We understand that,
Yes.
but then now it becomes your document. You have appended it.
Yes,
You
Your
have brought
Lordship.
into the records of these.
Yes, Your Lordship.
Now, what purpose? For what purpose you have
For
brought
what
it?
purpose, Your Lordship? This is the list where the name of the petitioner is not
So
reflected.
that is why the court is asking who has prepared this list. It's a part of that earlier civil rule of that 1999.
Yes, Your Lordship.
Yes. Then whose document it was in that case?
I have applied copy of the entire proceedings, Your Lordship, for
Whether
that,
it
but
was
let me
part of
assist the
affidavit
court
in
on this.
opposition, or it was a part of writ petition, or what?
It's part of the repetition, Your Lordship.
It means a document brought by the writ petitioner.
Yes,
And
Your
what
Lordship,
they
by the
said
writ
is,
petitioner.
it was a list prepared by the state.
By this Umpling Ranja Welfare Society, Your Lordship.
So what validity this document has? Are they,
I have
are they
applied from the
authorized
court.
to make a prepare a list? Are they holding the records?
I have applied from the court, Your Lordship, the entire record. Well, Your Lordship, let me come to the document which
We are
I'm
not
relying upon.
asking the genuine thing. Kindly understand which way you connect it.
It's connected with the document which I'm getting from the government of Assam, my Lordship.
You're referring to a list, you do not know who is the author of preparation, who prepared this list. This list originated from where?
From the Civil Rule 147.
So before that, the document was not in existence.
It was in existence
So that
existence
is why
in the
this
Civil
court is
Rule.
asking it originated from where? Please
From the
kindly.
Civil Rule 147 of 1999.
It's difficult to make you understand. Who made this document?
I have the entire. Let me apprise Your Lordship on the next for this. But Your Lordship, my main contention here, and I'm relying upon this.
See, if you rely on certain thing, you must be knowing about the document, the origin of the document, the purpose of prepared the document, who prepared it, and for what purpose, and whether the person who prepared it had the authority to make it or not. If you say this is a document from the records of the deputy commissioner showing the list of allotment, we'll go by that. But then you are not in a position to say it. Please verify. Mr. Thapa, you also come with a copy of this writ petition of earlier.
Do that now.
That is just see, after replication of mine for such a long time, and then suddenly you get disrupted for these reasons and that reasons, become difficult. You'll have it after vacation. There will be no time to do it next week. Hard. Learned Council. Just the matter was hard at some length. However, matter was on some length, however, the hearing could not be completed. Straightforward by the parties. This is matter for vacation. Please, Mr. Lindo, you see, whatever document you rely upon, please tell us what those documents and who prepared these documents, from where it originated. It is not enough that you procure it from other case records. We are not, you see, doubting the genuinity of this problem.
Yes.
The question is not to that extent. But then how far this document will bind us, that is the question. And for determining that, we need the source of this document, from where it originated.
I'll apprise Your Lordship.
Kindly,
Yes.
please do that. It is not enough that you come up with this document and just say that I have obtained from these things. You see, that may not be binding on us.
Lordship, in the next day, the petitioner can produce a writ.
We'll do that now.
petition.
We'll do the next.
At least the prayer part. The prayer part.
What we said before that, as provided this Okay. As for the parties, this is matter of permission. Okay. Then this the learned counsel for the petitioner shall produce a copy of the writ petition number
Number 370 of
W
2011.
is within bracket C number, then within bracket SH 370 C page, annexure 5 page 34 of the writ petition. You'll get the number.
370 of 2011.
What is the last name? Just the which was filed by him before this court on an earlier occasion. Thank you for reminding that.
The Lordship is correct. The prayer is important.
Prayer is important, and if you find that certain prayers you've made and that was not allowed, then you cannot renew that prayer.
But like we said, Malad, I've just read out that paragraph, Malad. The prayer was to restrain them from taking forceful possession, that's all. Because
Anyway, just produce a copy of the
Let's see the prayer. Once we read the prayer.
that can make the case more easier for Mr. Khan. You say the prayer expressly made, not granted, so it has to be taken.
we had molded the relief, Malad, in that.
Lordship, we have
by
heard,
following the spirit of civil.
we have heard that query falling and we seize the moment we thought there's going to be advantage to us. Let's see.
Anyway, sorry.
Obliged.